I'll go ahead and do a roll call. Let's see, Dr. Johnson? Here. All right, perfect. Thank you. Alderman Jean-Francois, not here. Alderman Witt? Here. Alderwoman Ray?
Present.
All right, on the agenda tonight, the only item we have is the 4-lot subdivision at Orange Terrace. I don't know how we'd like to start, if we want to bring up Mr. Fusco's here, I believe. If you'd like to just describe the project really quick, just give everyone a brief refresher on what we've been,
Sure.
what we have before us.
I'd be happy to. Al Fusco Engineering, 233 East Main Street. Our client had purchased 6 lots on Orange Terrace. They're 50-foot lots, and under the city code, they are required to be 75-foot. Right? And at one point, we were almost before the Common Council for 4 lots, but the applicant felt that he could get 6 lots. So he went to the Zoning Board of Appeals, and through a process, which the attorney will speak about it, I'm sure, is that we eventually got it to 4 lots with a 3.9% reduction in the width. Instead of 75, it was 73 and change. And then we went through the planning board process, and the planning board had your engineers, your planning board engineers, which are also the zoning board engineers, and we complied with everything they requested. I believe the commissioners reviewed it as well, and it's been referred to the Common Council. So we're here this evening to answer any questions you may have.
Thank you. Is there any questions directly for Mr. Fusco or for anyone on the council, not just the committee? All right, I'll bring up, oh, sorry. I'm sorry, yes, Dr. Johnson.
It's nice to see you, Mr. Fusco. I just wanted to be clear.
Mike.
I just wanted to be clear because the applicant has filed different plans over the last year or two, from 3 to 4 to 6. How many different plans has the applicant actually provided to the various agencies of the city, would you say, in the past?
This applicant?
Yeah.
Yeah. There are probably 4 different plans.
Thank you.
Yeah, you're welcome.
That's all I need to know.
Oh, Alderman Tobin?
So this is for 4 lots?
4
and the
lots,
width
that's
is
correct.
73 feet about?
Yes,
Okay. And the new requirement is 75, is that?
correct.
Okay. Thank you.
Thank you.
Alderman Witt, did you have a?
I did. You just said that your client purchased 6 50-foot lots, but it's only 288 feet.
I misspoke. One of them's a little shorter. I misspoke. I apologize.
Thank you.
Yeah.
Thank you. Corporation Counsel, are you prepared to speak on this at all, or no? Okay.
Hi,
Hi.
I'm Neil Frischberg. I represent the applicant. I have handouts.
Thank you, if you want to.
So, as you know, the applicant initially, sought a 6-lot subdivision and ultimately withdrew that application. So before you is the applicant Orange Terrace, who seeks a 4-lot subdivision from the Common Council under Section 420-2A of the Middletown City Code. The Zoning Board of Appeals, by decision and order dated March 20, 2024, granted Orange Terrace's application for an area variance, permitting Orange Terrace to obtain that 4-lot subdivision. And as Mr. Fusco indicated, the variance is approximately 3.9%. The Planning Board, by decision and order dated August 7, 2024, has referred this matter back to the Common Council. So what I want to speak about and what this handout is to address 2 issues. One, whether the Common Council should reconsider the propriety of the ZBA's granting Orange Terrace the area variance. And the reason I raise that is because during the ZBA proceeding, as well as the Planning Board proceeding, there were people who, like a Mr. Broker, I believe is his name, that kept questioning the propriety of the ZBA's decision. And so I did a little research, And because the ZBA has exclusive jurisdiction to determine whether or not Orange Terrace is entitled to four lots with the variance, that is not a subject for the Common Council. So eventually, you're going to open this up to the public, and I'm concerned that you're going to get a lot of people saying, well, why should you give a 4-lot subdivision to them? And they're going to talk about precedent and things like that, and that ship has sailed. Under what I view as clear precedent, which I've cited for you in this, the issue before the Common Council is what the 4-lot subdivisions are entitled to look like, not whether or not we're entitled to the 4 lots. The next issue is, since this application initially came before the Common Council back on, I believe, March 25, 2024, it automatically got referred to the Planning Board under Section 420-2B of your code. Yes, sir.
And I am hard of hearing, so maybe.
I'm sorry, I'll take.
No, that's right, it may have been that. You're telling us we can't deny it because they have a right to have it?
What I'm saying is, the issue as to whether we are entitled to 4 lots has been decided by the ZBA. The ZBA, under the statutory scheme and under the scheme in the Middletown City Code, has exclusive jurisdiction to determine whether an applicant is entitled to a variance. It has already done that. So when the applicant comes before this body, it's already entitled to the 4 lots. So it's not an issue for this council to decide whether or not the applicant's still entitled for the 4 lots. That's already been decided by the ZBA. And that, under your code, the ZBA has exclusive jurisdiction to determine that issue. So, for example, someone might come to you and say, well, why can't they just have 3 lots? And you may say, well, maybe you should have 3 lots. That's not something that this body can consider. The ZBA has already made that decision. If somebody didn't like the decision, they had the opportunity to appeal it in the form of an Article 78 proceeding. And again, I say this with due respect, but the way I read your code, specifically sections, hold on, I did cite the sections. Hold on, I just had it. Sorry, I should have memorized it.
No, that's all right. Our common counsel here, he's.
475-55D, and then also 475-55E and F of your code empowers your ZBA with exclusive jurisdiction to make these determinations. And in fact, the case law that I've cited you bears this out. That when a municipality has designated someone with exclusive jurisdiction to make a decision, such as a zoning issue, a variance issue, the other agencies cannot act as a sort of court of appeals or an appellate court. There's a process, there's an Article 78 if someone thinks it was arbitrary and capricious, and certainly the public had that opportunity, but that opportunity has passed. So the next issue is, since there's an automatic referral to the Planning Board under Section 420-2B, and the Planning Board has, in fact, examined the issues, the issues for the Common Council, I believe, is whether or not you have other issues that the Planning Board perhaps didn't consider. But right now, the Planning Board, in its own findings, determined that all the CPL, I'm just quoting it from the decision, all the CPL review comments have been addressed to the satisfaction of the CPL, and any items requested by the City of Middletown Planning Board and the City of Middletown Public Works. So those issues included, this is not an exhaustive list, but it certainly includes the necessary turnaround, because I know that became an issue. It included extending the road to the end of Old Lot 2 and New Lot 1. It included increasing the width of the road, I think, to 30 feet. It included the locations of stormwater drainage, and it would also included whether the subdivision was going to disturb any grave sites, because we have a letter to that effect as well. That's not an exhaustive list, but to me, those were the sort of the highlights when I attended the hearing. So what's left, it seems to me, is for the Common Council should declare itself the lead agency. And I don't believe any DEC approval is necessary, so we just need a neg deck on that, and then to schedule a hearing which I understand by your code can be done you have, I believe, 62 days to schedule a hearing and then another 62 days to have a decision. So that's why I submitted my little handout.
Commissioner. Okay. Thank you. Commissioner, if you'd like to, well, Alderwoman Ray, I'm sorry, did you want to speak first? You did have a question.
Well,
I don't
he
know.
could probably clarify after
Okay.
I speak. This will actually be the right time, I think.
Okay.
Just to get a better understanding, and I think you'll be able to clear it. But I
Thank
just
you.
want to state something while it's fresh in my mind. Because on page 4 of this document we've just been handed, it says that we can't determine how many lots, but with the common council, by contrast, has the power to grant the subdivision under the section. So we can just deny the subdivision? Because I'm really trying to understand how a board of appointed members have no oversight by the elected officials that oversee the city, that they can make a blanket decision and we have to honor it. Because we answer to the residents who live there, and normally when a variance is applied for, a public notice has to go out. The neighbors of that place in question need to have an opportunity to speak on it before it's granted. So to say that a board of appointed officials with no oversight can change the landscape of an entire neighborhood without any oversight by the people who are elected to protect those interests of those residents doesn't seem like it holds up to what you're trying to tell us, is that we have zero power here. Now, for me, I represent this district, this ward. I'm familiar with the neighborhood and the people who live there, and I understand what we're talking about with a couple of feet, but I do not believe with the amount of in and arounds that have gone on through this process that we are dealing with a scenario that's right. We have a city code for a reason. It's 75 feet for a reason. I don't see how the ZBA, who did not write that code for 75 feet, have the right to arbitrarily, without any checks or balances, make that decision above our own heads. So I'm reading on page 4, the Common Council, by contrast, has the power to grant the subdivision. Well, then that you leave us in a scenario where we don't offer a different number. We're not talking about 4, we're talking about yes or no. And if that's what's at the table today, then the answer is no, as far as I'm concerned, representing Ward 3.
Thank you, Alderman Johnson, you've been waiting as well.
Thank you. I appreciate it. You know, it's nights like this that I am reminded that I forgot to go to law school, but I did read it quickly. So, Counselor, it would appear you've tied this up with a bow, and there you go. But I'm not sure, because I forgot to go to law school. So, on page 1, you say whether the council should reconsider the propriety of ZBA granting, that we have no jurisdiction for that. That's what you're claiming, so to speak. And then you also say in item 2 that the applicant has met with the issues raised in concern by the planning board and is complying with his recommendations. I would need to be sure that that's a true, I'm not doubting veracity, but I need to be sure that's a true statement. Once again, I'm not familiar with the lingo. What does inter alia mean? Among other things. Thank you very much. I didn't take Latin either, so sorry about that. On page 3, you state, the city of Middletown vests, vis-a-vis to your comment, the city of Middletown vests its CBA with exclusive jurisdiction to decide when and if a property is entitled to a variance. So if that statement is true, the answer to your question is no. We, as a community, have vested entire jurisdiction to the ZBA. And obviously, I represent the Third Ward also. This has been, as you well know, ongoing around the Maypole. And we have an obligation to verify the veracity of everything you're saying. Thank you for listening. I appreciate it.
Would you like to come up to the mic and just speak on any of the? Yeah, sure. Okay, we're going to get. We're going to. Yeah.
So, in response to the concern by Ms. Ray, have I pronounced, and Mr. Johnson, the public had a full and fair opportunity to be heard regarding the variance. That application took at least 3 or 4, as I recall, meetings. And
that was before the ZBA?
yes.
Okay, thank you.
They had an opportunity to be heard, and they were heard. I was there, they were heard. And I would dare say, if I look back, most of those chairs were filled. So they had an opportunity to do that. And again, to Ms. Ray and Mr. Johnson's point, if they had an issue with that variance, they had the opportunity to file an Article 78 proceeding asserting that the ZBA's decision was arbitrary and capricious. So they did have that opportunity if they wanted to. Now, I understand that you are elected officials and represent the people of your ward. I get it. And I also understand that you have to look out for the best interests of your ward. I get that too. My client is now one of your constituents. So what he was asked the ZBA for was not a whole lot. He was asking for roughly 2.5 feet. And all he does was want to build 4 single-family homes on basically a street that dead ends into a cemetery. I think the people who voiced concern at the ZBA, some of their concerns were well-founded. I think they're entitled to be heard regarding water issues, traffic issues, and things like that, particularly on turnaround issues. We spent a lot of time on turnaround issues.
Yes, we did.
And I think they're entitled to be heard and should be heard. But my point is they were heard. And they were also heard before the planning board. And under your statutory scheme, the common council typically automatically refers the matter to the planning board for what I call the devil in the details type of inquiries. And the planning board did that. And again, the public had an opportunity to be heard before the planning board. So your constituents have had not one, but 2 bites of the apple to be heard. This is their 3rd bite.
Okay. So just to understand, having said everything you said and written, coming before this committee, what discretionary options do I have? If the way you're describing it, as Katie has said, we have no discretion.
Oh, I disagree. I think you have
Well,
discretion.
what are my
I think
choices?
your discretion is, 1, to grant or not grant the 4-lot subdivision, in which case we have our remedies, if you don't grant it. And 2, if you don't like the way that I think the way I read your code is that you don't have to take all the planning board recommendations. If you think the planning board missed something.
Not to be confused with the ZBA. You're
That's
talking
right.
about the planning board now.
Yeah,
Okay.
that's the way your code's written. You don't vest exclusive authority of what the subdivision should look like in the planning board. You're looking for recommendations from the planning board, and you want the planning board to take a deep dive into it. But ultimately, you get to be the decision makers on what the subdivision should look like. So, maybe you think the planning board was wrong. That's your call, I
But I
suppose.
can't override a ZBA decision, if I understand you correctly.
That's correct. You
So
cannot
that's like
tell
a
the
little bit of a
applicant.
checkmate thing, kind of.
Well, it's not a checkmate thing, and
I feel
Well-
checkmated.
well, I'm sorry. It wasn't my intention.
We have our corporation counsel here. If you wouldn't mind coming up and answering a few questions, please. I will, if he recommends it, we will do it.
I wanted Mr. Toledo to talk because I have not been involved at all in this
I apologize for bringing you
subdivision
up
for
on
the past few months. I know a little bit about the history, but I have not reviewed the ZBA proceedings. I have not reviewed the planning board proceedings, and I just got this memorandum of law about 10 minutes ago. But Mr. Toledo wants me to speak, so I'll just.
No, I didn't say that. You speak. You said, get up and speak. I said, okay, and then he referred to.
Well, yeah, if there were any legal questions on our
Legal
side.
matter, yeah, I would think it's a legal matter. The
Yeah,
man
legal
said We
questions.
have no authority, and Alex, you should tell us, do we?
Yeah, raise your hand if you went to law school.
I mean,
Thank
Alex,
you.
is it correct to say that while we can't argue the point of how many lots, we do sit here as a governing body with the right to deny it outright? It's a yes or a no.
Here's what I think.
Yes as is or no?
Here's what I think off the top of my head, having not had any chance to even read anything or research anything. The ZBA has authority to grant area variances, and I can see, and I believe we've done it in the past, where before the Common Council considers a subdivision application that involves the necessity for an area variance, the council or the Corporation Council would refer the applicant to the ZBA first, because it's the ZBA's prerogative, not the council's prerogative, to grant an area variance. But granting an area variance is not the same as granting a subdivision. The area variance has certain criteria that the ZBA uses. That's governed not just by our code, but by state law. And the ZBA has the prerogative to do that. You, as the Common Council, have a much different situation. You are there to determine whether or not the subdivision overall complies with all of the code requirements for a subdivision and is in the public interest for the city, for that neighborhood, and for the applicant. So I see it as two much different decisions.
Okay.
Area variance being one, and Common Council subdivision being another.
So
Any
we
more
do have
questions about that?
Thank you.
Oh, yes, Alderman Kleider.
What we kept hearing a lot was if the ZBA grants a foot and a half or a couple feet variance here, does that set any kind of precedent for the next applicant? Well, you gave them a variance, why don't you? And my answer to that was no. I think every ZBA application is considered on its own merits.
Well, and you're correct. I mean, obviously, any applicant can use past decisions of a ZBA or any board to make an argument that, well, you've done that in the past, what's different with mine? You can make that argument, but every applicant stands on its own feet based on its own facts. They're all different. Just as the request for an area variance is different from the request for a subdivision. Obviously, the council takes into consideration what the ZBA did, what the ZBA determined, because the council probably wouldn't want to act without a decision of the ZBA with the variance, because the council doesn't really have the power to grant variances. And that's why, I don't know if it happened here, because I haven't gone back and taken a look, and I have not read the ZBA minutes or not even the ZBA decision, but I assume what we've done in the past happened here, and that is that a suggestion was made that before you come to the council for a subdivision that requires variances, you go to the ZBA and get those variances. That doesn't, defeat or somehow take away the power of the Common Council to make the subdivision decision. Much different thing.
Thank you. Sorry, real quick, Corporation Counsel, in the interest of time, we were meeting tonight and we're going to vote to move forward to a public hearing. Is that, in your opinion, what we should do, or in your legal opinion, should we table and have you look over this memorandum? Does it have any bearing on the decision we would make?
I think, I mean, it's up to you, but I think you ought to move on to the public hearing. I mean, our code has timetables for the public hearing. There's no sense of this committee getting in the middle of those timetables and saying, well, we want to do this and we want to do that, when the timetable calls for, I believe it's about 60 days for a public hearing. So you might as well allow the council to hold a public hearing, and you don't have to make a recommendation to the council. You can hold it in abeyance, but we ought to follow our code and have the public hearing.
Thank you, I appreciate that. I'm just going to go around the room quickly. We'll start with Alderwoman Ray.
Okay. Yeah, I'll just say briefly that I understand this now. Thank you, Alex, for clarifying that, because that's pretty much what I read when I got to the end of this document. So we're not here to talk about number of lots. That's already been determined by ZBA. For the record, I'd also like to stay out without having,
Well, you say number of lots, but the ZBA determined that the
their
lots
variance.
deserved a variance. They
Right.
didn't determine that they ought to have those lots.
Okay, fair, even better. So excluding that ZBA decision, there's also, for a matter of record, my understanding that the planning board did not approve this as it is. So that's not, we don't have support of all of these boards, that's one. And two, that our decision to make as a council on this after the public hearing is whether or not we will grant the subdivision. So all this information about what the ZBA done is technically irrelevant. We're here to determine if this is good for the community or not. I'm happy with moving forward to a public hearing to discuss that further and then cast our vote on it as it is. But
Thank you. Dr. Johnson?
Thank you. So the outcome of the public hearing notwithstanding, if the committee or the council voted to not approve this project, not the variance, but the subdivision, what would you anticipate the applicant would, how would you anticipate the applicant would proceed?
Well, from It's hard for me to answer that because I don't know all the evidence that was put in front of the ZBA. Like I said, I haven't had a chance to read the minutes. I haven't even read the decision. Nobody asked me to.
Okay.
And nor have I reviewed in any way what the planning board did and what the planning board heard and why the planning board made its decision. So it's hard for me to answer that question. I don't know. And I don't want to guess and speculate what they might argue. And also, this application has a history even before, as Mr. Frischberg mentioned, even, there's been previous applications. I would have to go back and review all that, too.
Okay. There is one person in the room who might be able to speculate on how we might proceed. Mr. Frischman, I imagine you would not care to comment at this moment.
No, I wouldn't comment, but.
Makes sense.
Yeah, if you're going to speak, please come up to the mic. Yeah.
I'm sorry.
At this juncture, it's a little premature for me to comment.
Well stated, thank you. I couldn't resist.
Thank you, Alderman Tobin. You want to?
Yeah, I mean, I think we've seen this before.
Oh,
It's-
sure.
I think you see some speculation going on, like the definition I looked up, speculate, investing in a property in hopes of gain with a risk of loss. So they know there's risk, and then do we have to bend our zoning to, hedge their bets on, on buying the 6 lots that were not zoned, that weren't up to the zoning of today. So I just want to say that. And 2, I would like to, before we move on, probably go into an not tonight, but once he's reviewed all the material, go into executive session with the advice of counsel, just to kind of go over it and speak freely.
Okay, thank you. Mayor, you did want to speak real
Yeah,
briefly before we continue.
Isn't the street being narrowed too on this from 30 feet to 24 feet? And I don't think that's an issue for the ZBA. The ZBA can use that in determining whether there's an area variance granted, but the area variance, the decision to shrink that street should be part of the subdivision decision. And I think that was one of the major complaints of the neighborhood, was the street becoming much more narrow. And in order for them to meet their,
30 feet again.
they made it, I was told it was,
No, the new plans are back to 30 feet.
the new plans are back to 30?
Okay, new plans are back.
Oh, then,
Yeah.
I don't have the new plans then.
Yeah. no, I did-
What are the
I
most
didn't see
recent plans?
I didn't see the most recent plans then either, because the last ones I had were
Okay,
the narrowing, so.
so that was one of my questions I had, but we'll continue to review.
Okay. Yeah, Alderman, sorry, Dr. Johnson.
You can
Alderman-
call me-
Alderman
you can call me
Docker,
whatever you want. I did go to vet school, though. I didn't go to law school. Commenting on what the mayor just said, item 2 of councilor's point of view states, as demonstrated in point 2, the planning board has already identified issues concerning the application, and the applicant has modified the site to comply. Once again, I don't have a piece of paper that says what were the recommendations and how did they comply. I think that speaks to the width of the street, the turnaround, the infrastructure, the water, the myriad of issues that have been kicked around since we had this conversation start.
Yeah, did they comply at ZBA, or did they do this? in front of the
Counselor
planning
says
board?
it happened at planning board.
And what was the planning board vote? Do we know what the recommendation was from the planning board?
I don't have privy.
Well, they're right.
It was 6-1 against.
6-1 again, so the planning board had issues on it. Okay.
So I'm trying to understand.
No, because it was almost represented here that it was never said during the meeting that the planning board rejected the application.
Yeah, we
And I
said-
believe they rejected it based on a lot of the concerns that were raised at the public hearing and the ZBA public hearing. So if they changed if the area variance was granted to ZBA based on a 24-foot width lot, and I don't know if Mr. Fishberg can answer, was this changed at the ZBA or at the planning board?
Planning board,
So the ZBA, when the ZBA granted the variance, it was a 24-foot road.
I believe so.
Okay, so it changes, the whole plans have changed from ZBA, so that's my point.
Great, thank you.
Well placed.
Thank you. President Rodriguez, do you have anything you want to add? Okay, Alderman Massey?
I would like to move forward and at least have the public hearing and weed out all this stuff. And at that point, our corporation counsel will delve into it and be able to better advise us.
Thank you. Alderman Witt?
Yeah, thank you very much. Counselor, I appreciate your help with this because I didn't go to law school. I'm a journalism major. So I'm looking at this application or what we received, and I'm seeing 7 50-foot wide lots, and then one was 44.5, which is 94 and a half feet, which is, again, a different number than what we've been hearing. So this is what I know about, so I'm concerned about the stuff that I don't know about. Thank you, Alex. I appreciate your time.
Thank you. Alderman Kleiner?
Thank you. Yeah, I think going to the public hearing would be a good idea. I did go to all the planning board meetings and all the ZBA meetings, and I've heard this from its original working out with DPW to 4 lots, but that was going to be 3 regular and 1 undersized lot. And then it went back to 6 lots, and the reason given was to make more money. Well, because prices were going up, et cetera, and that was the main reason. But there were concerns about, well, you have historic Hillside Cemetery there, and it's on the National Register, and so there are concerns that will be raised, that issues that they have to meet and specifications that they have to meet to not impact the cemetery. But at the last planning board meeting, the planning board did vote no, although the planning board chairman did vote yes. And it was, the zoning board determined the area variance, and that's much easier to get than a use variance, but that was granted because they figured the variance from the 75 feet was basically insignificant, and they said it did not set a precedent. So I think it just needs to move on from this point, but I got the feeling, listening to all that the neighbors did not want the increased traffic, but this 6 lots or 4 lots or potential 4 lots or whatever, then should not have been sold for development. So I don't understand the whole process, and then how they, Mr. Fusco's been very good at coming to every meeting and explaining what they would do with the drainage and what they would do with the traffic. And they did not have an issue. In the end, the fire inspector, building inspector did not have an issue with the turnaround or the size or the plans as submitted. So I think we need to go back to the public hearing, see what the neighbors' at this point real complaints are, and go from there. Thank you.
Thank you. Before we move to a vote really quickly, Commissioner, did you have anything you wanted to speak to or add? Thank you. No,
So when you're referring to the comments of DPW, is referring to the, basically the building inspector and the fire inspector. I do have some minor comments in there,
Sure.
technical comments in there that I will address with the engineer, should you decide to go forward. And usually what you do is you, in the past, you approve it subject to DPW, technical review and approval. This is how usually the resolution comes in. This way will give us leverage to negotiate some technical issues or concerns.
absolutely. Thank you very much. Okay, at this time, I'll look for a motion to move to a public hearing. Okay, so moved by Alder, okay. Wow, sorry. Alderwoman Ray, seconded by Dr. Johnson. All in the committee in favor of moving to a public hearing?
Aye.
All right, thank you. And City Clerk will move to a public hearing.
There'll be a public hearing scheduled for October 1st. If the council approves it, it'll be on for tonight's agenda, October 1st at 6 p.m.
Perfect. Thank you very much. Can I have a motion for adjournment?
So moved.
All right, thank you, Dr. Johnson. Second,